Matter of Theodore Henry and Marilyn Henry versus Jeffrey and Keira Lowe. This is the defendant's motion for summary disposition. Defendant is represented by Dakota M. Hoffman, who appears by the Zoom application. Plaintiff in this matter represented by attorney Dallas L. Rooney. Mr. Hoffman, you may proceed.
Thank you, Your Honor. I just want to put on the record that my client Jeff and Keira Lowe are both present as well. So, Your Honor, I know you've read the briefing, and so I'm not going to belabor the points here, but just a little way of background here. This parcel was essentially the parcels that are fighting right now was one parcel owned by the Q-Nodes prior to 2005. In 2005, there was a split of the parcels pursuant to an agreement. Essentially, the Q-Nodes were receiving a enlargement of their home in 2005, and North Shore Development, who was the predecessor in interest to the Henrys, was receiving the parcel that the Henrys now have their property or have their home on. The agreement states that there's a home enlargement. It also makes way for an Exhibit C, which is what I believe to depict what the home enlargement actually was. Although we do not have Exhibit C, we do have the building permit, which ironically enough is attached as Exhibit C to my motion, which shows that a porch and a deck were both added in 2000, or both applied for a building permit in 2005. This is important because if what the Henrys are alleging is correct, and that there's a violation of the addendum, the violation would have occurred in 2006. We stand here, the property has not been changed since 2006. We stand here in 2026, nearly over 20 years later, and the Henrys are asking to demolish my client's retirement home, or at least parts of my client's retirement home. So my client purchased property in 2009 from the Q-Nodes. That's on some of the exhibits. It's listed as Parcel B. Parcel A is the Henrys parcel. The Henrys purchased in 2007. At this time, Your Honor, there are two procedural issues that I want to get into before the factual issue. Procedurally, this case has to be barred. It has to be time barred. It's either time barred by MCL 600-5807, which is a statute of limitation on breach of contract, enforcement of specific enforcement of contracts, or breaches on a covenant and a deed. It doesn't matter which one of those you choose, Your Honor, even though those statute of limitations have different year limits. It doesn't matter which one you pick because we're well past that time frame right now. If you take the most favorable statute of limitation for plaintiff, they had 10 years from the accrual of the claim, which would have happened in 2006. That's 2016. We're 10 years past that 10 years. Even if you give the Henrys the benefit of the doubt, which you shouldn't because it's when the claim accrues, the Henrys purchased it in 2007. So even if you give them that extra year, they're still time barred as of 2017. Again, we're nearly 10 years past their being time barred. That alone bars this claim. If Your Honor says, you know what, I don't feel that applies here, then we turn to latches. And this is a perfect case for latches arguments being made. It's been 20 years since this occurred. My client purchased this property, this issue unbeknownst to them. What the Henrys are asking for is to tear down large portions of my client's property, a deck that's been sitting there for 20 years. On top of that, we've got a exhibit which more than likely explains that this enlargement, which included the porch and the deck, was contemplated by the agreement and the addendum that the Henrys are seeking to enforce. We can't find it, likely because it's been 20 years. It's been 20 years since this should have been brought. Now, I'm not saying we're never going to be able to find it, but right now, neither party has been able to, and both concede that in their briefing. And this is a perfect time for latches to apply. The Henrys sat on their hands since 2007. They did nothing about this issue. Now, not only are my clients damaged, but they're also prejudiced because some evidence is no longer available. So even if the court says, no, we're not going to look at the statute of limitations, we don't think it applies, and then you move to the latches argument, you should still bar this claim because of the latches argument. And even if we move past the procedural issues with this claim, to which they are devastating, When we move past those and we get into the factual issues of this claim, they're seeking enforcement of essentially two provisions of an addendum. The addendum states that Unit B lake lot limited to build north, south, or up. Said building shall stay within 50 feet of the east property line with permanent structure. That's in paragraph A of the addendum. Paragraph B says mutual airspace for tree trimming and view enhancement. I want to focus on paragraph A first, because that's the one that causes more damage to my client, because it would incur them to tear down portions of their property that they've worked in. What paragraph A says, there's essentially three readings that you can do. If you read it with the agreement that it is an addendum to, it is either in direct contradiction because the Hunos were offering a split of the parcel and all of their covenants in exchange for the enlargement of their property. So either if the restrictions are in direct contradiction with the enlargement of the property, then the agreement in itself was contradictory upon drafting and upon signing, which Michigan laws doesn't look favorably on contracts that are contradictory upon signing. And in fact, Your Honor, in that case, this court would find that the contract's ambiguous. And if the contract's ambiguous, then that would still favor my client, because this court knows that the law in Michigan is that if there is an ambiguous restriction, that it should be decided in favor of free use of the land. The other option, and this is the option that counsel is proposing, is essentially you just don't pay attention to the agreement. You only look at the wording in the addendum. You just don't look at the rest of the agreement. And you say, listen, this is over the 50 feet marker. Because it's over the 50 feet marker, that's it. They got to tear it out. Well, that goes against Michigan contract interpretation principles as well, because you're supposed to look at the full agreement. Don't just look at one part of it, take it out of context. You have to look at the entire agreement. What I'm proposing is, which is, I believe, to be the only correct reading of this, is that paragraph was subject to the enlargements that were going to occur that were read into the agreement. So the enlargements were brought up, they were going to be done, they're part of the agreement, they're attached as Exhibit C. The restrictions say anything over that, that's a problem, right? That's where that would be a problem. If you do anything above what these enlargements are going to be that are contemplated by the agreement. My clients haven't done that. So at this point, the only reading that allows you to be consistent with Michigan law and to be consistent with reading the entire agreement is the reading that allows for this that specifically allows for the property to be in its current position that it is right now. Now, I want to turn just for a minute onto the tree trimming aspect of this case. That's paragraph B. Paragraph B states mutual airspace for tree trimming. Now, counsel is essentially saying you have to tear down the one tree that the Lowe's have in their yard. Now, I've attached the photograph into my briefing of the tree that is there. The paragraph says tree trimming. It doesn't say tree clearing. If it said tree clearing, that'd be a different story. That would mean you got to clear the tree. That's not the case here. Tree trimming would have to assume that there is a tree to trim, right? Not that you have to destroy the tree. So therefore, if it's overgrown, maybe they have a case. They do not in its current condition. The tree is very obviously trimmed to the best of its ability, and any further trimming is actually going to damage the tree. Going forward, I do want to touch on one more issue, and it's the issue of remedy. Council is asking for demolition to occur of the deck and the patio. They're seeking specific performance in that aspect. The problem is, based on his response, he has essentially foregone that remedy at law, because he says, and I quote here, any number of real estate experts could assign a monetary value to plaintiff's view. Well, that's the whole issue. They're claiming that the deck, the porch, the tree, it all gets in the way of their view, so it's all got to go. Well, if you're telling me, and they've already submitted this to court, so it's an admission to the court, that any number of real estate experts could assign a value to it, the court can't give specific performance anymore, because there is a monetary relief available. So even if the court doesn't want to dismiss because of the time bar, because of the latches, because of the actual interpretation of the document, even if we get all the way through that and we get to the very end of the road, this court should still grant a partial MSD onto the remedy here, because they cannot no longer go forward with a specific performance remedy when they've already conceded that there is a monetary relief available. Your Honor, I will turn it over to opposing counsel. I'll just save a little bit for reply.
Very well, thank you. Mr. Rubin.
Did you get the reply brief in today's mail from Mr. Hoffman?
Yes.
Okay. Just want to make sure you had it.
Defendants reply to it.
Yes.
Yes, that was received on August 19th.
I'm going to confine my comments to just addressing some of the issues that he raised in his reply brief. He starts out saying that plaintiffs have adopted the defendant's construction of paragraph A. That's been our position from day one, that you take that east property line, go 50 feet over, and that's the envelope within the building that to be done. So he claims it's a new reading. It's not a new reading. That's been our position from the get-go. Let's see. I think part of the misunderstanding here is that Mr. Hoffman wants to think that since the construction did clearly get built over the 50-foot line, that was what they intended to do. I think it might be a little bit of a speculation, but I think when they drew up the plans, I'm sure they intended to build that porch and the steps and the overhang within that 50 feet. But unfortunately, it got built over it. In big commercial projects, they have drawings of where things are supposed to be. And then after the thing gets built, then they have surveys called as-built. We don't do it much in residential, but I think what happened was the parties intended to build this new enlargement within the 50 feet, but unfortunately it did get built within 50 feet. And I think that's where the misconception is that Mr. Hoffman and I disagree on the fact that the words say what they say, and I'm saying that if they intended to do that, their agreement doesn't make any sense at all. It'd be like saying we're going to paint this room blue and then we paint it green. Well, the agreement said we were going to paint it blue, and now it's green. So I don't think it makes much logical sense to interpret that any other way. So Mr. Hoffman makes quite a few points about the consideration. Again, if the one party was going to get a lot, and part of the consideration for them receiving this lot was that the house built on the other lot was going to stay within 50 feet. So I think my clients who bought the lot from North Shore, they didn't get the benefit of the bargain. Where Mr. Hoffman wants to say, my people got the benefit of the bargain, but now they want to enforce the benefit that the other people got, which was having the house built plus some money and things like that they got in exchange for the, it's basically construction for a lot, basically. Mr. Hoffman is wanting to argue that there was an instantaneous breach. It wasn't an instantaneous breach until it got built over the line. I'm quite sure that they wouldn't have said, we're gonna build the new enlargement, but we're gonna stay within the 50 feet. We're only gonna build up or north or south or east, and then turn around and go over it. Doesn't make any logical sense to me. Defendants are worried that we're trying to condemn their property, we're going to demolish their property. Having been in the building business for many years, I don't think that the specific performance would be so horrendous. I mean, essentially, they have to reconfigure their overhang, maybe 18 inches, and the steps could be put in a different location because they're definitely quite a bit over. So we're not saying tear down their house, demolish their house. We're saying that one of our remedies could be moving this overhang, moving this porch, steps, and potentially moving this deck that's way out the back, which is like 9 feet over the. So the defendants wanted to come up with a kind of strained interpretation of the agreement now and say that what it really meant was, except the building that we're gonna build now, except for it, we can't be building over 50 foot or building any direction other than north, south, or east or up. Which I don't think, I mean, it's a strained interpretation in my view. And if we were to accept that, then we would have to say that the deck out back, which is not attached to the house, it's closer to the water, then it is a permanent structure. I've talked to building and zoning, it has a foundation. That permanent structure, even if we accept their concept that the new stuff is okay, but going forward, nothing can go over 50, well, now the whole deck out back has to go up. Fortunately. And this argument about latches. My interpretation of latches, the case law that I cited, has to put the other person in a worse position than my people. And I think they're both at an equal disadvantage, if there is one, about this missing exhibit C. They're both many years since the construction was done. They've both been owning the property for quite a while. I don't think either one of them is in a worse position than the other. The time factor hits them both equally, in my view. The unclean hands argument, I stated that my clients were bona fide purchasers for value without notice of the violations. In order to have unclean hands, there has to be some lack of good faith, there has to be lack of consideration. My clients had no reason to suspect that the porch and the steps were over that line until after they cleared their lot and built their house, and started looking out the windows and seeing how that interfered with their view. They had no inkling until that got done. They didn't survey the neighbor's property when they bought theirs. Defendants want to say that because North Shore built, or they say built or paid for, Juneo's improvements, that therefore my people have unclean hands. But the permit says Chinaski is the one that built the project, not North Shore. And just because North Shore paid for the improvements doesn't mean that North Shore violated the construction. If I was building a project for you, someone else was paying for it, you and I are still the ones that have to be making sure that it's getting built where it was supposed to be built. So I think there's a breakdown in the linkage for the unclean hands. I'm sure that North Shore paid for it, I'm assuming they did. But Chinaski is the one that built it. And Junados, if it was enlarging their house, I assume they would have been there or checking in on the construction when they got it done. They could have got it surveyed to see if it was all within the 50 feet. And I think there was an obligation on the part of the Lowe's when they bought it to do the same. I've pled for either specific performance or monetary damages. Either or. Part of the reason is there could be a wide range of estimates on what it would cost to rebuild the overhangs, move the porch, move that deck. There could also be a wide range of values on what Realtor A could say, yes, this view, if it didn't have the tree, would be worth X dollars. And another realtor could look at the view and come up with something else. I think it probably would be a wide range of numbers, both for the specific performance and for the value of the view. So which one of those would be more reasonably certain, I think, is the question that the judge would have to figure out at some point. Defendants counsel wants to say that because I pled both, or I've said that realtors could come up with a value, that therefore I foreclosed specific performance. And in construction cases, it's very often a case, specific performance to fix X. It's going to cost this many dollars. Move a building, something like that. It's often impractical. And a judge won't make someone do that. But in lieu of that, they would give them monetary damages for the loss of value that they received because of the way it was built. So construction cases, all the time, it's specific performance or monetary damages, depending on how the circumstances end up. Mr. Hoffman says that a restriction on the use of land that must be litigated to learn whether it authorizes removal is not authorized removal. And I can tell you, I can't give you a case name right now, but there is case law in Michigan where somebody built a house in the wrong place, or they built not a stick-built house, but they built a factory-built house, or they built a garage, and at the end of the day, they had to tear it down or move it. So the fact that, and those cases all had to get litigated to figure out whether they could or could not, or did not have to remove them. Mr. Hoffman says that plaintiffs are permitted to trim the tree if it becomes overgrown. Technically, they're permitted to trim the tree for purposes of view enhancement, not whether it's overgrown. He says that the tree's been trimmed to the maximum extent available. Says who? He also says that any further tree trimming will damage the tree. That's why I said in my answer was that whether it can be trimmed and not hurt it, or whether the trimming will hurt it or kill it, is something that's gonna have to be figured out. We'll have to have an expert arborist or something determine that. But tree's gonna keep growing, and it's gonna keep restricting their view as time goes on. And because these restrictions run with the land, it's my opinion that if Henry sold their house, which they're not intending to do, that's gonna be their retirement home too, once they get fully moved in. But if they sold that to you or me or Joe Blow, I think Joe Blow would still have the right to trim that tree for their view enhancements, because it runs with the land. The tree's gonna get bigger and bigger over the years. So I guess in closing, that what the damages could be would have to be determined, whether they're monetary damages or if they are a cost to reconfigure the deck, overhang, porch, and that deck that's out back. That's all I have.
How do you respond to the statute of limitations argument?
Well, I think I put in my answer that my clients only came, they bought a vacant lot up here, they live down in Royal Oak. They only came up intermittently, less than once a year to view the property. They didn't realize that there might be a problem until they got their house built, looked out the back windows. And when they came to see me, the first thing I told them they had to do was get a survey to see whether it is or isn't. So I think it's a discovery issue. I think Mr. Opperman says that discovery of the issue wouldn't apply. But that's their excusable reason for not doing anything till now, because they had no inkling.
Your clients,
Yes,
they purchased the property in 07.
he did, yep. And then he added his wife on several years later, which is within the 6 years. So that's an argument, I guess.
Anything else? No. Rebuttal argument, Mr. Offer.
Thank you, Your Honor. I just want to hit on a couple things, and I think I want to touch on what plaintiff counsel just spoke about, and that's in regard to the statute of limitations argument. The claim begins when it accrued. So whenever the breach occurred, or the breach of the covenant, breach of the contract, meet the ability to enforce specific performance, whenever that occurred, that's when the accrual starts. You don't get to just add somebody onto a deed and then say, oh, they're onto the deed now. They can go forward with the deed. If you were able to do that, there'd be no point in having a statute of limitations at all, because anybody could just give their claim to a relative and have their relative fight their claim. That's not how any of this works. The accrual of the action happens whenever the breach occurs, assuming there's a breach. And I think I would still argue that based on my interpretation of the contract, there's no breach. But even if you assume for a minute everything they're saying is true, and that there was a breach, and that a breach occurred at the time of the enlargement, we know when that happened. That happened in 2006. They had, at the most forgiving, 10 years from 2006. That was 2016. They didn't do anything. And, counsel says, well, they just didn't know. Well, that's their fault. That is their inattention to their claim. My client didn't tell them, don't go get a survey. In fact, if you have a piece of property for over a decade and you intend to build on it at some point, logically, you probably want to get a survey of that piece of property sooner than later when you buy it. The inattention to their claim does not dismiss their ability to, or doesn't provide them some discovery rule exception later on. You don't get to be an ostrich, stick your head in the sand, and then when you pop it out, say, all right, well, I'm gonna fight it now. You don't get to do that. So that's the issue in regards to the statute of limitations and the latches argument. They don't really have a response to that. Council's response is that, well, you know, they just didn't know. That's not a response to that claim when the claim accrued. On top of that, they talked a little bit about whether or not this was the enlargement occurred over the boundary and how that could be problematic, and you know, maybe it was an accident. The issue with whether or not it was an accident, North Shore Development is the party under the contract that's responsible for the enlargement. So if it's an accident, if it's in the wrong place, if anything is wrong, that's North Shore's problem. So, and again, it wouldn't be an issue because North Shore owns, you know, they are the only party that could enforce these restrictions. So to them, if it's off, okay, whatever, it's off. It doesn't matter. As we go through this, Your Honor, there really is no reason that this claim should have been filed. If you just look at the procedural aspect of this, there's no reason this claim should have been filed. The tree, I know the tree's an issue. You can look at the tree yourself. We have photographs of it in the briefing. The tree is cut as much as it can. What council wants is it torn down. It doesn't say that in the restriction that it has to be torn down. Nowhere in there does it say that. You can't just say, well, you got to keep trimming and trimming and trimming until it dies. No, you trim an overgrown tree. That's it. I mean, that's the only logical interpretation of that paragraph that you can have.
Well, but it doesn't say overgrown in the language, though, does it, counsel?
No, it says tree trimming for view enhancement. But
Right,
it doesn't.
but you can't just interject that because that's not what's contained within the contract language.
Correct, Your Honor. But there has to be some standard. I think Your Honor would agree with me. There has to be some standard for what trimming would be, correct? Somewhere in there has to be a standard. Right. So, and that's sort of what I'm proposing. There has to be a standard. It doesn't say it in the lease or in the agreement. It's not defined. You know, if trimming was defined as the diameter of the branches of the tree can go no farther than 10 feet, you know, then this would be a lot easier. But it's not. So we got to look at what the ordinary interpretation of that section would be. And tree trimming doesn't mean tree trim it back until it dies. Otherwise, they would have just said clearing of it. Right? Tree trimming has to mean something. It has to have some standard. And the only standard that makes any sense would be an overgrown standard, whether the tree is overgrown. If council has a different opinion or some other interjection or some other definition, I'd be happy to hear it. But I haven't heard one aside from trim it back till it's completely gone. That's the only definition I've ever seen from council that he's provided. So, you know, in regards to and I would still fall back on, if this was an issue, they've had to pass 20 years to bring this up. And they didn't do it. So procedurally, with the statute of limitations and with the latches argument, it's still out. They still lose.
Mr. Hoffman, for purposes of this hearing, the Lowe's purchased their property in 2009, correct?
Correct.
The Henrys purchased their property in 2007.
Correct, but I will just add the caveat, as council mentioned, Miss Henry was not added to the deed until 2020.
Agreed. But your position is that since 2007, Mr. Henry, one of the plaintiffs in this matter, had the property.
Correct.
And the building was put up, or the enhancements were done prior to that.
Yes, the enlargements took place in 2006.
And what do you believe is the applicable statute limitations, period?
So, Your Honor, I'm frankly, and I'll be frank with the court, I'm split between two. It is either section 1 of MCL 600-5807, which is a person may not bring or maintain an action to recover damages or money due to breach of contract or the enforcement of specific performance of a contract. That's within 6 years for a breach of contract. The other one is section 5, which would be 10 years based on a covenant in a deed. Now, I think it's probably section 1, but even if we're being as generous as we can be and we give them 10, and they still lose.
All right. But you would agree, though, that the restrictions run with the land, each parcel. You would agree with that?
I would agree with that here, yeah.
Okay.
But the difference would be that when the breach occurred. So, you know, that's when it accrues, when the breach occurred. Assuming there's a breach.
And are you aware of any, and I'll ask Mr. Rooney the same thing, are you aware of any tacking that can be utilized to enhance the statute of limitations in a matter like this?
I am not.
Mr. Rooney, you're not either? No. Okay. All right, I'm ready to make my ruling on this matter. I'm going to tell you right out of the gate, relative to C8 and C10, I guess there are a number of ways of looking at this contract. And also wondering whether or not the real party at fault is the individual that sold the property to begin with. But be that as it may, relative to C8 and C10, I'm not even going to state the standards. And the reason I'm not going to is because normally in cases like this, and clearly any party is entitled to file a motion for summary disposition in lieu of an answer, in the event that it's based upon law and fact. Well, as it pertains to C8 and 10, though, clearly there's more discovery that would have to be addressed for the court to have a better understanding of what's going on, because there's interpretations that could be abound here. So the court's denying the motion relative to C8 and C10. Now, relative to C7, here, summary disposition may be granted where entry of judgment, dismissal of the action, or other relief is appropriate because of release, payment, prior judgment immunity, statute of limitations, etc., under RCL 2.116C7. Clearly, before the court at this time, well, let me back up a bit. A party is not required to submit any material in support of a motion under C7. It can be evaluated on the pleadings alone under Maiden versus Rosenwood. And the contents of the complaint are accepted as true unless contradicted by documentation submitted by the movement in this matter. A party may support a motion under C7 by affidavit, deposition, admission, or other documentary evidence, again citing the Maiden case. The court must review all documentary evidence submitted by the parties, accepting as true the contents of the complaint, unless affidavits or other appropriate documents specifically contradict them. That's the Ono case at 495 Mich 982. That's a 2014 case. Here, there is no question that in the year 2006, according to the complaint and statements of counsel, essentially, in 2006, there were two properties, the Henrys and the Lowe's property. The North Shore Development Deed deeded its lot to Mr. Henry. So Mr. Henry received as plaintiff property January 20, 2007. Obviously, in 2006, prior to that, the defendants had their property. I'll call it the addition or the improvement or the enhancement was done during that time frame. Actually, before the Henrys purchased their property. Properties purchased, and nothing was developed on the property for many, many years because apparently it was wooded, and it was eventually going to be a lot that the court can gather for purposes of clearing it and eventually setting their own retirement home on it, which clearly they did down the road. Now, mind you, much later, there was a quitclaim deed to add spouse, I believe it was spouse, Keira Lowe, maybe she's not a spouse, but regardless, I'm sorry, Marilyn Henry was added. So you have to look at, well, what is the deed contain? It has to be this within 50 feet, et cetera, all well and good, but clearly one party says, no, it's in violation. The other says, no, because it's so ambiguous. But regardless of the ambiguity, you have a duty to call and move your claim forward within the appropriate statute of limitations timeframe. And it appears to the court that that timeframe under MCL 600.5007 parens 1 would be 6 years. But even if the court granted or found that it would be under section 5, 10 years, we're still talking over 20 years before this was addressed. And one could say, well, sure, we bought the property, we were there just, a couple times a year just to check on it, etc. However, that's when the action started. Once they gained access, once they owned that property, essentially, hindsight's always 20/20, but a survey probably should have been done way back then, and it wasn't. And it may not have been discoverable just because of the fact that you have a wooded area, you have no idea where your parcel is going to be in conjunction with the other property. I can understand that, but really the claim began as soon as that, frankly, as soon as the plaintiffs took possession. I should say, had the deed to the property. You could even argue that it was even before that with the prior party in interest, but that's neither here nor there. I'm looking at from the time that the Henrys took the property. And under C7, this court finds that statute of limitations has run relative to the improvements to the neighboring home. The claim is time barred by the statute of limitations, and the court grants summary disposition under C7 to the defendants. However, regarding the infamous tree, there are sufficient questions of fact that does run with the land. And so as a result, we still have the tree to contend with, frankly. And so the court is going to order an answer relative to the tree issue. And it may be a point where, and I've done this before, Mr. Rooney is familiar with this. I like to go out to the property just to see what it's all about. And I would do that with counsel only. And I'd be willing to do that. But all other claims pertaining to the deck, to the overhang, clearly they're in violation as far as if you look at the one interpretation, but it's time barred. So motion for summary disposition again granted to the defendant relative to that issue, present an order to that effect. And again, relative to C7, C8, or C10, there's a sufficient question of fact when you consider the pleadings pertaining to the tree. That matter stays alive. Present an order to that effect, Mr. Hoffman.
Thank you, Your Honor.
That'll be all. Thank you.
Thank you.
Oliver.